really enjoyed it. Are we ready to go?
Yep.
So let's talk a little bit about leasehold estates. Uh, a leasehold estate is the tenant's right to possess real estate and is considered personal property. I would know that, Christine. Christina. Christine, just Christine. I would know that, Christine. Okay, that a leasehold estate is personal property. It's not real property. Okay, so when you have a lease, it's personal property. It could be, and this is a little bit confusing, but we're going to get you through it. It could be an estate for years. Now, the tricky thing with an estate for years, it could be for years, it could be for weeks, or it could be for days. But the key is it always has a specific starting and ending date. So that's how you have to remember a estate for years. And look, write it down. So the key for an estate of years, Samantha, it always has a start date and an end date. Okay? And it could be years, it could be months, or it could even be days. Then you have an estate from period to period. It's an agreement for an indefinite time, no expiration date. It can be week to week, month to month, year to year, until proper notice is given. Okay? That's an estate for period to period. So let's say Lexi is renting a house. She can do an estate for years, and that would be a case where she would negotiate with Tammy, who's the landlord, a lease, and that lease could start today. It could end in a week, a month, a day, or a year. But the key is with that estate of years, it has a specific end date. It has a specific end date. Starting on this date, ending on this date. Okay? The estate from period to period would be if Lex had that lease and it was month to month. And it goes on until either Lexi gives notice that it's over or the landlord gives notice that it's over. There's no end date with an estate from period to period. An estate at will consists with the consent of the landlord for an unspecified term until proper notice is terminated is given. See, the period to period had a term, didn't it? Month to month, right? Day to day, week to week. An estate at will would be if Lexi said, how about if Tammy said, go ahead, Lex, you can live there until you give notice. It's very close to an estate from period to period. The difference with a period to period is it's either week to week, month to month, or year to year until notice is given. Estate at will is there's no period. Just live there until you give me notice. Very similar, Ray. But the difference is period to period, there's a time frame. It could be day to day, week to week, month to month. And then estate and sufferance. Oh, that's where Tammy is the landlord, Lex is the tenant, and Lex does not leave at the end of the lease. You're suffering, aren't you, Tammy? Because you got this pain in the butt tenant in there, it's not paying any rent and staying, right? So an estate in sufferance arises when the tenant who's legally obtained the possession now illegally is in possession. So Lexi had an estate for years from Tammy Haywood. And in that estate for years, Tam says, okay, we're going to make a month to month. And if I want you out, I'll give you notice. If you want out, you give me notice. Right? That would be an estate for years. Period to period. because it's month to month with no end date. And then Tammy gives Lex notice that she wants her out. Lex has been in a bad way. Ain't paying her rent, and she says, no, I'm not leaving. So Tammy gives her a notice to evict, to leave, and Lex stays there anyway. You think that happens? All the time. That's an estate in sufferance, because really the landlord's suffering. But let's see if I have a video here.
Grammarly does more than catch errors. With Grammarly, you can find really good. No.
Pass your real estate exam with PrepAgent.com. Remember, keep it concise and keep it simple. A less than freehold estate is an estate held by one who rents or leases property. Classifications of a less than freehold estate includes an estate for years, periodic tenancy, estate at will, and an estate at sufferance. An estate for years is a leasehold interest in land for a fixed period of time. It is often called a tenancy for years. An example of an estate for years would be a summer rental, as it has a defined beginning and end date. Terminating is needed as the end of the lease is established. This is great for a landlord. Tenant the moment your rental begins, because he knows when you are leaving. Periodic tenancy is a tenancy that is not bound to a lease with a fixed period like an estate for years does. A periodic tenancy follows a period such as month to month, week to week, or year to year. You commonly see this as a month rental. Proper notice must be given to terminate this lease so the landlord has time to find somebody new. An estate at will gives the lessee the right to possession until the estate is terminated by either party. The term of this estate is indefinite. Basically, estate at will means that it can be ended at any time. End at any time? That sounds terrible. What could possibly be worse than that? What could be worse for you as a landlord is when you want to end it, but the tenant does not leave. This is an estate at sufferance. This arises when the tenant wrongfully holds over after the expiration of his term. An example of an estate at sufferance would be a tenant that does not pay rent but continues to live there. You may know this as a deadbeat tenant. An easy way to remember this is that in an estate of sufferance, the landlord is, well, suffering. This is not a form of trespass, as at one point the tenant had the right to be on the property. The landlord would have to legally evict the tenant when a tenancy of sufferance is created. For more great information to get past a real estate exam, remember, go to PrepAgent.com.
You guys ever go to high school and you always had a teacher that played movies and videos? Anybody ever have a teacher like that in school? I loved that teacher. Huh? Now I know why he did it. Not that he was lazy, that sometimes another person explaining something helps it to stick. Does that make sense? I always thought he was lazy, just put a video up. And sometimes hearing it twice, hearing it from somebody else will help it stick. I'm going to help you get through this test, I promise you. Jason, do you have any doubt that I'm not going to help you get through this test?
No.
Good. So you guys just stay engaged, show up, do your homework, which is to read ahead and review back, and look at the terms in the beginning of each chapter and kind of know those terms. Who's doing the cards? Ray, you doing the cards?
Yeah, I'm doing the cards and just basically doing test questions.
Okay. Do you have the cards with you today?
Yeah.
Okay. Well, you don't get them out right now, but next break, get them out. Maybe we'll play with those cards a little bit. You know, maybe we'll throw something up on a screen. Let's talk about the types of leasehold estates. Is a leasehold estate real property or personal property? Personal property. The lease is personal property. Okay. And we said estate for years, periodic. We went into that. There's no use double. But here's the 4 different ways it can go. And this is maybe in your book somewhere. Is it? on 82. So you get a leasehold estate could be in a state of sufferance, a state of will, period, and a state of years. What's the difference between an state of years and period? Put your hand up if you know the answer. Ellen.
The years has no specific end, or no, has a specific end date, period doesn't.
Right. And then what's an estate, the difference between an estate from period to period and an estate of will? Put your hand up if you know it. Christine?
From period to period, like month to month.
Okay.
And then I say, I will, is you live there forever until like the tenant or the landlord.
Yeah.
They want there.
Yeah, you know, yeah, you stay there until you give me notice. Okay, and then the state of sufferance, that be tenant, right? We got that down. Let's talk about a lease agreement. It's a contract between the owner of the real estate, the leaseor, and the tenant leasee. So there's an OREE rule that you guys are going to have to learn. Okay? In the next break, Andrea, will you remind me to dig it out of here somewhere?
What is it?
OREE rule. Typically, why don't you look through there, see if you can find it, Andrea, in the OREE rule. Typically, the OR is the person giving. Azaria. I get it right? Azaria? I'm getting better with that, aren't I? So if I'm the leaseor and if I'm the landlord and Lazaria is the tenant, I would be the leaseor because I'm giving her permission to live in the property. She would be the leasee because she's getting that permission from me. So the OREE rule, a lot of times as we start going through stuff, they'll have an OREE on it, and you won't know which one's which. But that little story, and maybe Andrea has a handout that'll help. Okay, a lease may be written, oral, or implied. A lease has a reversionary right to possess remained by the owner. So a leasehold estate is never forever. It could be if nobody terminates, but the owner always has a right to get that property back. And the owner, who is the leaseor's interest, is called a lease fee estate.
Nobody likes waiting around for a device to connect. But with the HP Plus Smart Printer, a connected device is waiting for you.
Gotta listen to the ad, guys.
Nice one.
HP Plus.
Pass your real estate exam with PrepAgent.com. Remember, keep it concise and keep it simple. In a lease, the landlord is the lessor and the tenant is the lessee. Remember, OR gives and EE receives. Oral leases can be binding, but generally leases are written and give exclusive possession of the property to the lessee and a reversionary right to the lessor. A reversionary right means the owner has the right to regain possession of the property after the lease has expired. Just like in any other contract, a valid lease must contain mutual agreement, consideration, capable parties, and lawful object. The lessee, which is the tenant, has the right of quiet enjoyment and possession of the property, which is the assurance that their possession will not be disturbed by anybody with superior title. Which, by the way, makes that whole premise of that great 80s show, Three's Company, with Mr. Roper barging in on Jack Tripper, a little bit flawed. Anyways, let's move on. The lease is a bilateral contract with both the landlord and the tenant have obligations to perform. Remember, bilateral means a promise for a promise. I promise to let you live in the property if you promise to pay. The lease agreement can restrict the tenant's use.
So we're not even to contracts yet, but since he's talking about bilateral, I want to explain the difference between a bilateral and a unilateral contract. Okay? A bilateral contract is a promise for a promise. So a bilateral contract would be a lease. Tammy is agreeing to lease the property to Lexi. In turn, Lexi is going to agree to pay Tammy rent. Okay, bilateral. A sales agreement would be a bilateral contract. Seneca is agreeing to sell to Samantha the property, and Samantha agrees to give Seneca compensation. Bilateral, a promise for a promise. Now, when we get into listing agreements, we'll talk about this again, Ray, but a listing agreement would be a unilateral contract, right? So if you're the seller and I have a listing agreement with you, it's unilateral, meaning I'm not obligated to sell the property, right? I try like hell, but I'm not obligated. She's obligated to pay rent. She's obligated to give possession. She's obligated to pay compensation. She's obligated to give the property. On a listing agreement, it's unilateral. I'm not obligated to sell, but if I do, he's obligated to pay me a fee. See the difference, Christine? Mm-hmm. Okay.
Use the property and specify the conditions of which security deposit may be retained and the duration of the rental. Death does not usually terminate the lease. Upon death of one of the parties, the responsibilities, as stated in the agreement, could pass on to the heirs of the deceased. Remember, leases are personal property as they do not always run with the land. Meaning, when the property is sold, the lease does not always transfer with it. It is a contract with an individual person. As a way to remember the lease is just a piece of paper. Pieces of paper are movable. Therefore, a lease is personal property. Unless the lease forbids it, the tenant has the right to assign or sublet the property. What's the difference, you ask? Well, it's simple. An assignment is a transfer of contract rights, whereas a sublet is when you rent the property, you lease it to another person while still maintaining a responsibility to your landlord under the rental agreement. For example, if you sign your lease to Bob, you can move on with your life and Bob is now responsible to the landlord. If you sublet your lease to Bob, if the landlord does not get paid, you are responsible regardless of what Bob does or does not do.
Okay, so Snowballs signed a new lease. And she put in that lease that she could sublease it. Meaning, if Snowballs decides that they don't want to rent that space, they could sublease it to Samantha. Now, Samantha could come in, pay the rent, pay the Snowballs. Snowballs then in turn would pay to the landlord. If Samantha quits paying rent, Snowballs is still responsible. An assignment would be where Snowballs assigns that lease to Samantha and Snowballs is out of the picture. And if Samantha doesn't make the lease payments, Samantha would be responsible for the damages to the landlord. Now on the sublease, Samantha could still be responsible, but she's going to be responsible to Snowballs, not the landlord. Snowballs is still in the picture under the sublease. The assignment, Snowballs is out of the picture, and Samantha now is responsible to the landlord. Make sense? Okay. I think we're learning some stuff. Huh? Seneca?
Constructive eviction is a term used in the law of real property to describe circumstances in which a landlord either does something or fails to do something that he has a legal duty to provide. An example would be if the landlord refuses to provide heat or water to the apartment, as a tenant cannot live without water, thus they need to vacate the premise. This would be constructive eviction. For more great information,
Do we got constructive eviction? Give me an example of that, other than the example he used. Go ahead.
The rental place, and you're having weeks into it, some trouble with the toilets. And found out they were probably connected sewer. So it was leaking out in the yard. They're like,
That could be. And you couldn't live there anymore. Or if the place burned down, or the roof burned, there was a fire, and the roof burned up, and water was coming in. Or if the landlord agreed to provide water and electric, and he didn't pay the electric or water bill, and you didn't have any water or electric. Leases combine two contracts: conveyance of possession in the real estate and a contract to pay rent or assume other obligations. The landlord receives the payments for use of the premise. It's pretty self-explanatory. The landlord retains a reversionary right to possession at the end of the lease term. What's required of a valid lease? Capacity to a contract. What do we mean by capacity to a contract? Legal capacity. How old do you have to be to sign a contract? Pennsylvania. 18. If Lex signs a contract with Tammy, but Lex was at the Foster house all night drinking and she's drunk, that could be an invalid agreement. Legal objections. You can't have a contract for something that's illegal. Okay. Offer and acceptance and consideration. And pre-printed leases are available. We do leases at our office, and we have a pre-printed lease that we use that we fill in the blanks. Commercial leases are often very complicated. But we do commercial leases at my office, and we've leased out a lot of commercial properties. They're just a little bit more complicated. Typically, the broker gets involved to make sure that there's not any problem. Possession of the premise is quiet enjoyment. What do we mean by quiet enjoyment? Lexi will have quiet enjoyment of that property. Sheila, what's that mean?
But me as a landlord can't just go in there at any time. I better know it.
No.
Okay.
Nope. We talked about quiet enjoyment before.
Or she has the right to enjoy the property as long as she's not disturbing anybody else.
Nope. Nope. Ray?
I don't know.
Look in the back of the book, see if it's in there. Oh, wait, we're getting close. We're getting close. What's quiet enjoyment mean? Oh my God. Quiet enjoyment.
That it's legal.
What?
Not doing anything illegal.
No.
She's allowed it.
Okay. Quiet enjoyment means, and you get that too when you get title, that Lexi has quiet enjoyment. She's leasing this property off Tammy, right? She has a year lease. Oh, a year, a lease of a lease 10 years, and it's for 365 days. Sheila can't come in 2 months from now and say, get out. That's what it means. Somebody can't come in and interfere with her rights. She has quiet enjoyment. She has a right to live in that property for the term of that lease, and somebody else can't come in and say, I bought the property, Lex. Lease is terminated. No, the lease would still run its term. Does that make sense?
Yeah, I was reading.
Garrett? You was reading into it. Well, quiet enjoyment is tricky because you think I'm enjoying it. No. It means somebody can't come in and step on her rights, I guess. Conditions under which a landlord may enter were typically spelled out in a lease. You know, a lot of times they'll say they went 24 hours, so they just can't come barging in. The use of the premises would be in the lease. What are they going to use it for? Snowball's lease says it's used for a hair salon. There's restrictions in commercial spaces, and it has to be a lawful purpose. In Pennsylvania, there's no real estate transfer taxes. There are real estate transfer taxes on leases longer than 30 years. Does anybody know what real estate transfer taxes are? Yeah. So when you sell a piece of property in the state of Pennsylvania, the state charges 1%. And then the county would charge, and in Westmoreland County, they charge 0.5%. And then the township or borough would charge. And Ross Draver charges 0.5%. So when we sell a piece of property in Ross Draver Township, we have to pay 2% transfer stamps. Okay, 1% goes to the state, 0.5% goes to Westmoreland County, 0.5% goes to Ross Draver Township. Now, some places like Pittsburgh, I think the state gets 1%, the Allegheny County gets 0.5%, and I think Pittsburgh may charge 4 or 5%. So different areas have a different transfer stamp. And when you take that deed to the courthouse to record it, that's when you have to pay them. When you do a lease, if Flex does a lease for Tammy for a year, there's no transfer stamps paid. But some commercial leases are real long. And if that lease is over 30 years, then real estate transfer taxes may have to be paid. Okay? Security deposit in Pennsylvania may not be considered rent. You have to pay interest. If it's over $100, the landlord or real estate company would have to pay interest on that money. You can have a bond in lieu of escrowing. So in Pennsylvania, the landlord may purchase a bond in lieu of putting that money in the escrow. So when we used to do property management, the biggest reason I got out of property management, and I don't know if I think a landlord would have to pay the interest too. Every time, we had like 30 rentals, and every security deposit, because we had to pay interest on it. Does anybody get a checking account here? I mean, what's the interest on a checking account? Nothing, pennies on $1,000. But we had to put every deposit in a separate account so that we would know how much interest at the end of that lease we gave back to the tenant. And in some cases, on $1,000 deposit, it was like $2. Okay, but we still had to do that. So the Landlord Tenant Act of 1951 governs security deposits. Security deposits may not be considered rent, and they may not be used, Lex, for the last month's rent. So you can't say, Christine, keep my security deposit for the last month's rent. You're not allowed to do that. You have to pay your last month's rent. Then typically the landlord has, in PA, typically it's like 30 days to give that rent back. In Pennsylvania, the first year's deposit cannot exceed 2 months' rent. At the beginning of the second year, that amount drops to 1 month. So if you're paying $1,000 a month rent in Pennsylvania, the landlord could say, I want 2 months rent, $2,000. But at the end of 12 months, if the tenant's still in there for another term, you have to give them $1,000 back. Okay? Everybody got that? Improvements. Neither landlord or tenant's required to make improvements. Okay? So, Sheila, you rent a place that has bad windows. You can't bitch at the landlord and say, hey, those windows are bad. I want you to replace them. He's not required to make improvements to it. The landlord must allow persons with disabilities to make responsible modifications, and the tenant must restore at the end of the lease. So let's say that Jason has a disability and he wants to put a ramp in so that he can get up with his wheelchair into the house. The landlord can't say, you can't put that ramp in. But at the end of the lease, he has to take the ramp out. Okay, and restore the property back to the present condition. Questions on that? Ray? Maintenance. Residential leaseors. Who's the leaseor? The tenant or the landlord? OR is the person giving, right? And I got to make a note that I have that ORE rule at the office. I'll have to bring it up here. Residential tenants must return to premises in the same condition they received it. Commercial tenants usually maintain the premises. So I have a unit that I rent, and it's a residential unit. It's my own personal property. And when the air conditioner goes in the summertime, it's a residential. Typically, the landlord's responsible for the maintenance on a residential. I have to go down and fix the air conditioner, or if the furnace goes, or recently the faucet broke in the kitchen, try to go down and put a new faucet in. Snowballs has a commercial lease. Okay, so it's Snowball's commercial lease. They're responsible for all the maintenance. So if the furnace goes, Snowball's responsible. The light fixtures, the lights go, Snowball's is responsible. So typically on commercial, the tenant is responsible for the repairs versus residential, typically the leaseor would be responsible. If you were going to record a lease, it would be recorded in the county that the property is located. Typically, residential leases are not recorded. Maybe if a lease is for more than 3 years, it may be. I've never personally seen a lease recorded. Options grants the leasee the option to renew or extend the lease. Okay. So some leases may give the leasee, Lexi is the leasee, right? Tammy's the leaseor. She may have an option to renew the lease. And a lot of times on commercial leases, hey, there she is. So when Snowball's had a commercial lease, the lease before, she had an option to renew it. At the end of the first year, she had an option to renew it. At the end of the second year, she had an option. And a lot of times on commercial leases, Ellen, they'll put that in there. So because the tenant wants to be able to stay there. They typically, Ellen, on those options, there'll be an increase in rent. You know, like 3%, whatever it is. Discharge of a lease. When the parties fulfill their agreement. If the lease agreement has been met. If it's a lease for years, and it's for a 6-month period, starting on January 1, ending on June 30th. On June 30th, the lease would be discharged if both people paid the rent, if the people paid the rent. If there was a destruction of the premises, if the place burned down, if part of it's damaged and it's residential, they may reduce the rent and still live there. Assignment, transfer all the leaseholder's interest to another party. We talked about the difference between assigning and subleasing, right? Does everybody have that one down? Breach of lease. You can sue for possession, actual eviction. Breach of lease in Pennsylvania, you have to give 15 days notice, 2-3 months notice, depending on the time of year. So Pennsylvania says that You can give, in the summertime, and maybe you only have to, so Lex is not paying the rent. Tammy wants her out of there. In August, she may be able to give her 15 days notice to vacate. And then if she doesn't vacate, she can take her to court. In January, she may have to give her 1 month, 2 months, up to 3 months, depending on the laws. Okay. And then if she doesn't leave, then you can take her to court, Tam. You can take her to court. Only a constable can forcefully remove a tenant's belongings. Okay? Only a constable. So, Tam, poor Lexi's getting picked on here, isn't she? Lex is renting this place from you. And you have an estate at will created, right? So she's able to stay there until she gives notice. You're able to stay there until you give notice. You decide you want to sell the property. So you want the tenant out so that you can show the property. Because tenants in property are always hard to show. So you give her notice to vacate in 30 days. She doesn't vacate. You can take her to court. The court rules that she has to leave. She still doesn't leave. She has her stuff in there. You can't go, even though you have a court ruling in your favor, you can't go throw her stuff out. A constable has to do that. Okay? Constable has to do that. Tenants' remedies for constructive eviction. The tenant must move out. In Pennsylvania, the landlord has to warrant that it's habitable. The Landlord Tenant Act of 1951 delineates remedies for landlords if the lease is in default. Fair housing and civil right laws affecting. Now, this is not even in the book, is it?
That's unit like 22.
Okay, well, we're gonna skip over it then for right now. But let's talk about it. So there are fair housing and civil right laws affecting landlords and tenants. Okay? Can't discriminate against the protective classes. We'll get into the protective classes. All persons must have an opportunity to rent, and all persons must have accessibility. Okay? So, a big mistake a real estate agent could make with all people have a right to live regardless of race, color, creed, national origin, handicapped, that you showing a tenant properties. And you say, okay, we're going to meet at 123 First Street. You meet there. The tenant comes in a wheelchair van. Tenant comes out of the wheelchair. And the house has a set of steps going up to the first floor. The real estate agent may say, you know what, this ain't for you because there's not easy access to the house. That's discrimination. It's not up to the agent to tell somebody where they want to live. That's discrimination. Okay? That's discrimination. You can't tell somebody where they should live. They have to make that choice for themselves. Even though you think you may be trying to help them. Now, if the guy says, hey, I'm disabled, I'm looking for first floor units only, different story. But if he doesn't tell you that, and he wants to see a second floor unit, and there's no elevator, you can't say, well, that's not going to work for you because it's the second floor. It's not your place to say that. It's not your place. It's not your place. Let's talk about the different types of leases. Okay. And again, my slide presentation doesn't follow the book exactly, but that's okay. You're learning. There's a gross lease, okay, where the tenant pays a fixed rental amount and pays for everything else. The landlord pays everything else, used for the residential and commercial office leases. So a gross lease could be Lexi's renting off Tammy, and Lexi pays $100 a month, and the landlord takes care of everything else. The utility bills, the maintenance, and everything. Okay, and a lot of times that's used in residential and commercial office leases. You know, maybe you have a building that, you ever see a building that has 2 or 3 different, you go in one door and then there's 2 or 3 different offices. You may have an attorney, an accountant, a real estate company, and a doctor. So a lot of times the landlord will say, your rent includes all the utilities. A net lease, the tenant pays all expenses, including taxes and insurance. Okay? So in that case, Snowballs pays all the expenses, and they would even pay their share of the taxes and insurance. That's a net lease. A percentage lease, the rent is based on the minimum fixed rent plus a percentage of the income. You ever go to the mall? You ever see those kiosks in the middle of the wall when you walk by? You can get your earrings pierced and all that kind of stuff. Buy cell phone covers. A lot of times those are a percentage lease. So the mall says, okay, Lauren, you can lease this space for $100 a month, but then we want 10% of your gross revenue. Next, more the landlord gets. That would be a percentage lease. Lease allows for specific rent increases, set future dates. So when Snowballs did their lease, they have a variable lease because it states in 5 years, the rent will go up to X amount. A lot of times it's every year. But in the lease, it's spelled out that it may be a 10-year lease, but year 1, your rent's this, year 2, your rent's this, year 3, your rent's this. A ground lease, the landlord leases unimproved land and the tenant erects the building. So that's a pretty good deal, huh? So Lowe's and Walmart, I think those are ground leases. They leased the land to Lowe's. Lowe's built what they wanted to build there. Oil and gas rights you can lease down underneath the ground. Lease purchase. You can have an agreement. Lex could have an agreement with Tammy that she's going to lease that property, but at a specific time, she could buy that property. And usually they negotiate the price prior to. So I had a property in West Newton one time where my tenant had, it was a lease purchase, and he was, well, a lease purchase is a little bit different. A lease, you would lease it and then purchase it. That would be a lease with the option to buy. My tenant had. He can rent. Portion of his rent would go towards the purchase price. If he exercised his option, then I would have to sell the property to him for a agreed upon price. Is that a unilateral or bilateral contract? Man, it looks like everybody's just stuck in the mud today. Is it me, Ellen? Huh? No? Thanks, Laura. If I had $1, I'd give it to you. Okay, a lease purchase, the tenant has a right, a lease with an option to buy. The tenant would have a right to buy, but he doesn't have to. But the landlord would have to sell. So that would be a unilateral, meaning the landlord would have to sell, but the tenant doesn't have to buy. Does that make sense? Unilateral, one person. Bilateral, both people are doing something. Okay. And sell and lease back. Gabriel Brothers did this. They sold the building that Gabe's is in, but they sold the building, but then they're leasing it back off of the new owners. Anybody go to Gabe's here? Okay. Now, why would they do that? Maybe they needed to raise some capital. Maybe they needed to raise capital. So you have a business that needs some money. They could sell the building, but then for $1 million and then lease it for, $20 grand a month. Maybe they needed that $1 million to put back into the business to keep it going. Go ahead, Squirrel.
Never mind.
That's a sale and lease back. Okay, that's the end of that, Andrea. If you want to wrap that up. End of unit 5. It's 5 to 11. Let's take a 5-minute break and then we'll get into unit 6.